Welcome to this episode of WAHNcast, the podcast where we highlight the experts shaping the landscape of affordable housing. Today's discussion delves into the unique and often challenging circumstances of general partner litigation, particularly in the low-income housing space. Our guests, Quin Seiler and Christina Loukas, will share their insights from real-world cases they've encountered, though it's important to note that the situations we discuss involve a small number of investors. First, we have Quin, whose career at Winthrop has given her the opportunity to represent real estate developers, both for-profit and nonprofit organizations, in disputes with limited partners as they exit the partnerships. While the majority of these exits proceed smoothly, Quin has been involved in cases where conflicts arise, including over purchase options, rights of first refusal, and appraisal disputes. With a focus on resolving disputes out of court whenever possible, Quin is known for her clear guidance and aggressive defense when litigation becomes necessary. Outside of her legal work, Quin is a triathlete and former Division I All-American soccer player. Joining Quin is Christina, an expert in real estate and construction law. Christina has represented developers and general partners in low-income housing tax credit-related disputes, often during the investor exit process in year 15. Though these disputes are not the norm, Christina has seen firsthand how a minority of investors may attempt to interfere with general partners or challenge their contractual rights. Her extensive litigation experience also spans construction law, contract enforcement, and title actions. In addition to her legal practice, Christina mentors young attorneys and serves as vice president on the board of the Minnesota Women's Affordable Housing Board. Outside of work, she enjoys spending time with her family and indulging in her love of baking. In this episode, Quin and Christina will share stories from their careers, focusing on the complex issues they've encountered and offering insights on how to navigate these challenges. Let's dive in.
My name is Christina Loukas. I'm a shareholder with Winthrop Weinstine in Minneapolis. I am a litigator. My practice involves principally construction and real estate litigation. And for the past decade or so, I have focused primarily on year 15 issues in affordable housing.
My name is Quin Seiler. I'm also a shareholder at Winthrop Weinstine in Minneapolis. And my practice has focused on representing real estate owners and developers with a focus on affordable housing. And as kind of a subset of that, I end up doing these year 15 litigation disputes as well with Christina. And so we wanted to kind of kick this off and talk to you guys a little bit about year 15 issues in the low income housing tax credit space. So let's talk a little bit about the low income housing tax credit program and big picture. How are these deals structured? If you're listening to this, you probably already know, but I think it's important to provide just a little bit of context. So developers of low-income housing tax credit deals end up applying to a local allocator. Here in Minnesota, that's the Minnesota Housing Finance Agency, for an award of tax credits for their development. They then seek out an investor to invest equity into the development, and in return, they get tax credits. So as part of the structure of this deal, what happens at year 15?
So year 15 in the low-income housing tax credit or LIHTC world signifies the end of the initial property compliance period, as well as the end of tax credit recapture exposure. So typically the tax credits are paid out over 10 years, but for that first 15 years that the project is in service, they can be recaptured if the project is out of compliance with the relevant government regulations. Typically at year 15, the investor in the LIHTC deal exits because at that point, the investor has realized all of the financial benefits that it expected to receive. Usually, the limited partnership agreement that governs the relationship between the investor and the general partner, or the LPA, provides a mechanism or multiple mechanisms for the general partner to acquire the investor's interest or the property and get the investor out. In the last decade or so, we've seen a lot of disputes arise at year 15 relating to investor exits. So Quin, what are some potential indicators that your deal might have some year 15 issues?
Yeah, so these are things that you should just kind of be looking out for when you're getting close to your year 15 of your development. One thing to look out for is that your investor or your limited partner in your partnership is managed or is affiliated with an organization that has previously been involved in litigation. I would say that these quote unquote bad actors in the industry tend to be repeat bad actors. So we see the same names coming up again and again regarding these kind of year 15 disputes, and they're repeatedly in litigation. So if you know or are aware or do some research and find that these people have done this before, there's a good chance they might want to do it with you as well. Another red flag is that the limited partner has pushed for liquidation of the partnership. They want to wrap it up, have the partnership be done, sell the asset, and they want to get as much liquidity out of it as they can. This should be something that for you is a red flag, because they should be wanting to get out, but they shouldn't be having any interest in the kind of dissolution of the partnership. One of the largest red flags is that that limited partner is no longer the party with whom you originally, quote unquote, did the deal. So if you have a different limited partner than when you first negotiated this deal back 15 years ago, there's a chance that they may have alternative interests. This is particularly important if the limited partner ended up acquiring their interests after the 10-year period when the tax credits were issued. If an investor came in and got these interests at year 12, there really wasn't any benefit to them because they didn't get any of the tax credits during the first 10 years. So they're potentially looking to try and have a windfall or try and convert what may have been pennies on the dollar for their investment into a large influx of capital to them. That's something to really look out for. And it's a real red flag if the one who came and stepped in after year 10 is an entity who previously had litigation. Another red flag is that the limited partner has a positive capital account, a large positive capital account, and they're looking to potentially get paid off on that large capital account. Another one is when the investor begins asking questions about operations or routine financial decisions. They may ask for an audit. This is all of a sudden an interest in the property or the operations of the property that they never have cared about before. This is something that they may be trying to find potential violations of the partnership agreement and use those as leverage. So if you have all of a sudden a very interested limited partner, this is something that you should maybe be wary of. Another thing is that the limited partner withholds approval for necessary repairs, updates, refinancing. They really have no interest in the long-term value of the property anymore. And so they do not want kind of routine repairs done, or they may be interested in trying to refinance and get a cash payout. So keep an eye out for that. Another issue is they discuss refinancing or resyndication, once again, as a way of getting extra cash into the partnership to potentially buy them out. So if there's a claim that the general partner says, hey, I just don't have the money to pay you, an extravagant amount that you may be looking for, they'll say, oh, well, let's do a refinance or a resyndication. That'll get the cash in the pocket so that you can pay me the big bucks. So keep an eye out for that. These are all red flags that you should be looking for. What do they actually end up looking like at year 15, or, why might they arise? So Christina, I'll touch on that.
So we see a number of recurring year 15 issues. The investors tend to push on the same types of issues. So one thing that we have seen a lot is interference with the general partner's exercise of its right of first refusal or its purchase option. So we've had a number of instances where the investor has challenged the general partner's exercise for one reason or another, from, technical, didn't provide the notice within the timeline or in the correct format, to saying that the holder of the right of first refusal is not a qualified nonprofit, to raising other issues with the valuation or how much needs to be paid by the general partner for the interest. There are lots of ways that this comes up where the investor partner tries to interfere with the exercise of those options. We also see it come up with refinance demands. So the investor partner will withhold consent to a routine refinance or be demanding additional capital, like Quin had just mentioned, attempt to get some cash out through a refinance rather than just provide their consent to refinance the mortgage on the deal. We see a lot of valuation disputes where there is a dispute over how much the partnership interest or the property is worth. We see forced sale attempts where the investor partner will attempt to force the general partner to sell the property, sometimes in spite of the general partner's other rights under the LPA to either acquire the property or the partnership interest. One of the other issues we see is removal of the general partner. The investor partner will sometimes use technical infractions or breaches of management responsibilities that the general partner has, such as, maybe they got some tax returns out late, or they hired a new management company without getting the appropriate consents or something like that. And the investor partner will attempt to use those actions to get the general partner removed, because by removing the general partner, then typically the general partner cannot exercise its other rights under the LPA. So let's dig a little bit deeper into some of these issues. Quin, do you want to talk about the nonprofit right of first refusal?
Yeah, so the nonprofit right of first refusal is a right that is granted under Section 42 of the code, and it gives nonprofit developers or sponsors the right to purchase the property at a below market value that's typically debt plus taxes. And the right of first refusal, due to tax reasons, I would say is somewhat vague under the code as to how it can operate. It is technically phrased as a right of first refusal, and it is triggered by the partner's agreement to sell the property or upon receipt of a third-party offer. But the code is vague, and so this allows the partnership agreement to fill in these gaps. And so at year 15, there will end up being issues regarding the exercise of this nonprofit option. But a number of those issues can be addressed through delicate drafting of the partnership agreement. It's important that this is drafted properly or in the way that it's intended for the parties to exercise it, because it is intended to protect the long-term affordability of the project. How can you address this in the limited partnership agreement? One thing to make sure is that it's drafted so that a bona fide third-party offer is not required in order to trigger the right of first refusal. So in a traditional right of first refusal situation, the partnership would receive an offer to purchase the property, and that would normally trigger the nonprofit's right to purchase the property at this below market value of debt plus taxes. Now, there has been litigation about what kind of offer does there need to be? Does it need to be a bona fide offer? And when I say that, that means, does the offer need to be from a completely separate third party who doesn't have any interest in either the general partner or in the property? And they're coming in and saying, hey, I'm interested in purchasing this property. And do they just come out of nowhere? That would be a bona fide third party offer. Now, we want to make clear for the interest of the nonprofit that this does not require a bona fide third party offer. Instead, it could be coming from affiliates of the nonprofit or related entities, or they could go out and go to their buddy who's a developer and say, hey, would you be interested or willing to make an offer on this property in order to trigger my nonprofit right of first refusal? We want to be clear in the partnership agreement that a bona fide third-party offer is not required so that they can do that, so that they can go and find and solicit a third-party offer in order to trigger their right of first refusal. So that should be clear in the limited partnership agreement. The other thing to keep in mind is, while it is structured or it's stated in the code that this is a right of first refusal, if you want it to operate like a purchase option, draft it in a way so that you only need to manifest an intent to sell the property in order to trigger the right of first refusal. Draft it so that they can unilaterally exercise this right. Another thing to keep in mind is that you want to ensure that the party holding the right of first refusal is a qualified nonprofit. Christina has specifically had litigation where, through some, I don't want to say careless drafting or
A Scrivener's error.
A Scrivener's error, yes. So a drafting error, the party that ended up holding the right of first refusal was not actually a nonprofit. And she had to go through extensive litigation in order to ensure that that nonprofit right of first refusal could actually be exercised. To be clear, this statutory right of first refusal under Section 42 of the Code is only for nonprofits. So if you have a for-profit general partner, what you might have or what you might try and draft to include in your partnership agreement is a purchase option. So Christina's going to touch a little bit on what that purchase option may look like.
So when you have a for-profit developer, or sometimes even if you have a nonprofit developer, you might want to have this as an alternative option to the right of first refusal. You should probably include a purchase option in your LPA. And what that means is that usually at year 15 or at year 14, right, the last year of the compliance period, the general partner will be able to exercise an option to purchase either the partnership interest or the property. We typically recommend that your purchase option be drafted so that the option is to purchase actually the partnership interest of the investor rather than the property itself. This is because it's typically more of a financial benefit to just purchase the interest rather than the property for a number of reasons I'm not going to get into. But we generally recommend that you're purchasing the interest rather than the property outright. Because we do see a lot of disputes about how these options are exercised, it's important to ensure that your LPA is very clear about what's required to exercise that option. So one of the things that's important is that there is sufficient time permitted to exercise the option. Sometimes there is a lot required for the general partner to put together to exercise an option. And you want to make sure that you have sufficient time to get all that together, whether it's getting appraisals done, getting financials put together. You want to make sure you have enough time to do that. So we would usually recommend that you have a year to exercise that option. We also recommend including a tolling provision, which would mean in the event of a dispute over the exercise of the option or other disputes that arise in the context of the partnership, that the general partner's ability to exercise that option is going to be tolled or, extended for the length of that dispute. That prevents any other disputes about whether or not the general partner may have missed an option window if it didn't exercise or wasn't able to actually complete the transaction within the time period allowed in the option period. It's also important that the provision makes very clear what is required of the general partner to exercise its option and that the requirements are not overly onerous. So as I just mentioned, we see partnership agreements sometimes that will require the general partner to take a number of steps to exercise its option before it can actually deliver it to the investor partner, which might include significant appraisals, getting the financials all worked out, having tax opinions done, some of these things that can take months of time to get accomplished. And that can really hamper the general partner's ability to get everything done on time and can also lead to other disputes about whether or not all of those steps were completed correct. I think Quin actually had some litigation about some very onerous requirements on a general partner and whether they had actually complied with all of those. So it's something that can easily lead to disputes. It's better to just draft that provision in the LPA so that the requirements are clear and easy to accomplish. Now, in connection with the sale of partnership interests, your provision is also going to include a portion about how to value the interest, right? So we also want to make sure that our LPA very specifically defines how the partnership interest, what that purchase price is going to be. Another issue that we see when we're talking about the sale of a partnership interest or a purchase option is the valuation. It's also really important as you're drafting your LPA to ensure that the way you have drafted the provision for valuing the partnership interest that's being purchased, ensure that that's very clear. It's very easy for disputes to arise over the valuation of a partnership interest. We want to be as clear and concise as we can at the outset to try to limit the disputes that might arise. So some of the things that we recommend in drafting these LPA provisions would be that you include language that takes into account discounts for lack of marketability, lack of control, rent restrictions, etc. Those types of things should be accounted for when you're looking at what the value of the partnership interest is. You also want to make clear that the valuation is being based on the value of the interest and not on the value of the project. Again, because you want to take into account some of the things I just mentioned about lack of control, lack of marketability, et cetera, because those things tend to push down the value of a partnership interest. You want to also ensure that your LPA is addressing capital accounts. One of the things that investors have really tried to push with a lot of litigation around the country is that they are entitled to a return of their capital account because the LPAs are not drafted specifically enough to really expressly define what happens to a capital account after disposition of the property. So we always want to ensure that our LPA very clearly addresses what's going to happen with that capital account to try to head off those types of disputes. If there is going to be an appraisal process, we want to specify the method for selecting the appraiser, ensure there are not restrictions on using an appraiser with whom the general partner has a prior working relationship. And we typically, it's very common for an LPA to include an MAI requirement for the appraiser. We try to keep that out of LPAs because it tends to exclude a lot of really qualified appraisers. And again, we're looking for appraisers who can really value a partnership interest rather than the real estate. We also want to be very clear about how fees are being calculated and when and how they're paid in the waterfall provisions. I've had a couple of cases come up with disputes over payment of various fees that are included in the waterfalls and how those get calculated or when they might need to be paid. Quin, I know you've had some litigation on some valuation issues. You want to give us a little real world anecdotes?
Yeah, so I had one case in particular where there was a dispute about which waterfall provision should be utilized when calculating what the limited partner should be paid upon exercise of the purchase option. And that went on for years, actually ended up going to trial. The biggest thing as part of that dispute was that the limited partner was trying to claim that it should be under a waterfall, which entitles them to a return of their capital account balance. And if I remember correctly, that case had their capital account had about $1.2 million in it. And so they claimed that in addition to a lot of other things they should be paid, they should also be paid a return of their capital account. So that went all the way to trial. Thankfully, we got a pretty quick verdict, and the jury found that they weren't entitled to a return of their capital account. But that's a pretty typical, I would say, valuation type issue is where do we end up, right? Like, where do we end up in the partnership agreement as far as determining what the limited partner should be paid and how is that calculation done? And the clearer it's made that, for instance, they aren't entitled to a return of their capital account, the better it is and the more likely you will be able to have a successful. It's worth noting that in that litigation as well, we had an appraiser issue in that we had to submit an appraiser to the limited partner as part of the exercise of the option. And they just kind of refused to approve the appraiser, refused to go down the process because they did not like the way that they were valuing it. So it just kind of held us at a standstill and required us to litigate the issue. So that's something that's come up and is, I would say, kind of a typical presentation of this type of dispute.
One other issue that we see come up with investors is attempting to exercise forced sale rights. So the LPA might have a provision that does allow the investor to force a sale of the property. Sometimes the provisions will be contrary to other provisions in the LPA that may give other rights to the general partner, or they have gotten creative with some language in LPAs to try to convert what's actually a qualified contract provision into a forced sale right. And we've seen investors have some success with this. You know, as we're drafting LPAs now, having learned from some of these issues, we always recommend that you don't agree to include a forced sale right, or at a very basic minimum, make it clear that any forced sale right that the investor partner may have cannot be exercised until after the expiration of any like right of first refusal or purchase option period. It's kind of surprising how often sometimes these rights exist concurrently in the limited partnership agreement. And, you know, anywhere you have conflicting or contrary rights, it's ripe for a dispute. And we also recommend just not including qualified contract provisions anymore. They typically are not permitted in a lot of states or frowned upon by the housing agencies in any case, but they have been utilized in various litigation to attempt to force the general partner to sell the property. So we generally recommend that they just not be included in the limited partnership agreement at all. If your investor is insisting on having a qualified contract provision, then at a minimum, it should be made very clear that that provision is specifically for the qualified contract process and not to be used as a mechanism to force the sale of the property. Another issue that comes up is when the investor has rights to consent or not to actions that the general partner wants or needs to take. Quin, do you want to talk a little bit about consent rights?
Yeah, so unrestricted consent rights can lead to a number of different disputes. So how this is typically framed or phrased in the partnership agreement is stating that the consent of the investor limited partner may be withheld in the LP's sole discretion. And this can kind of come up in a number of different contexts. One context would be that you need the consent of the investor limited partner in order to refinance, or you need the consent of the investor limited partner to change management companies, or you need their consent in order to hire an accountant, right? It could come up in any number of contexts. And this can really create issues because the investor limited partner now essentially has a sword, right? That they can wield this sword, in their view, to try and leverage certain conduct or action that they may want from the general partner. So if the language of it is that they can withhold their consent in their sole discretion, arguably that gives them a lot of power, that it gives them the power that they can, for any reason, withhold their consent. Now, courts haven't always agreed with that, but it has definitely been used as a weapon. So one of the things that we try to do in the limited partnership agreement is to first limit the general partner actions that require limited partner consent, right? Try to have it as few issues as you can where you actually need to go to the limited partner and get their consent. But for those ones where you can't avoid it, use language that consent may not be unreasonably withheld, conditioned, or delayed. That means that they can't use it just for no reason. They can't just say, no, I don't want to do it. They have to have a legitimate reason, and they can't delay it. They can't wiggle around it. They have to have a legitimate reason for withholding their consent. Now, this has come up, as I mentioned, in the context of refinancing, where they withheld their consent. We've also seen it coming up in the context of trying to change management companies. And the investor partner has come in and said, whoa, you need our consent. And we don't consent to this. And they've even done it after the fact. So the general partner has already changed management companies. And then 2 years later, the investor partner comes down the road and says, at year 15, and says, you weren't allowed to do that without our consent. That was a breach of the partnership agreement. We can now remove you as the general partner. This is a really important provision or important context that needs to be addressed within the partnership agreement. And Christina, has actually dealt with this as part of litigation before. So if you want to touch really briefly on that, Christina.
Yeah. So I've actually had refinance consent rights come up in 2 separate lawsuits. One, it arose when the mortgage was about to mature and the general partner needed the limited partner's consent to refinance. And this deal actually didn't have any exit provision in the LPA. It was an older deal and they just hadn't provided an exit option. So the investor decided to try to use this refinance consent to force the general partner to do a cash out refinance and put a whole bunch of debt on the property. I want to say, if I remember correctly, it was like $1.4 million, which would prevent the general partner from doing a bunch of capital improvements that needed to happen. It would have, increased the monthly payments on the deal and really financially stressed the deal going forward. And we actually had to go and file a lawsuit to demonstrate that the investor partner was not acting in the best interest of the partnership and that it did not have a right to withhold its consent to get cash out. It was a right that it didn't have under the partnership agreement. And we ultimately did win that case, but it was an expensive piece of litigation for the general partner to get to that decision. I had it come up in another situation where the investor partner had actually missed its window to exercise an option to exit. And so when the general partner went to them to request consent to refinance, they tried to use it to strong arm them into buying their interest to get out at an exorbitant price. And the general partner said no. And we ended up having to go through litigation. And that case ultimately settled just before trial. But, that was after we had actually won summary judgment in the general partner's favor. The court said the investor partner did not have a right to use its consent rights to get something out of the agreement that it wouldn't otherwise have, i.e., the purchase of its interest when it didn't otherwise have a right to force the general partner to do that. So that's a couple of situations in which it's arisen. Consent rights are particularly an issue when you have a problematic investor. Quin, do you want to talk about how to avoid getting a bad actor in your deal?
Yeah, so this, as we mentioned kind of at the very beginning, one of the issues that we have or that we often see is that vulture limited partners end up entering the deal at some point during the first 15 years. So it'll typically be between year 10 and year 15, but they end up buying out the investor partner's little limited interest. Then they try to capitalize on that. And so one of the kind of important mechanisms that we have encouraged our clients to try and include in their partnership agreements is giving the GP consent rights to the transfer of the limited partner's interest. In an ideal world, it would be that the general partner needs to consent to a transfer, any transfer of the limited partner's interest. Now, we've received a lot of pushback on that type of provision. We have gotten it approved a few times, but that would be in an ideal world, that the limited partner would say, yeah, I get it. You want to consent to this. And, we could have it say something like that consent won't be unreasonably withheld, conditioned, et cetera, et cetera. But the alternative that we've proposed is a list. So it restricts the limited partner from transferring their interest to a list of what we view as bad actors. So these vulture investors who have been involved in litigation in the past, you include a list that says that you can't transfer the interest to those entities or anyone affiliated. They're wholly owned subsidiaries or affiliates. It can't be transferred to any of those. We have had some success with that. You can also include limitations on the transfer to any entities who have been involved in litigation with respect to the transfer of limited partners' interests. And if you have a good investor limited partner, they may agree to that type of language because they want to do deals with you in the future. That is a real important right that we try to include for the general partner. Because if you have no control over where those limited partner interests end up going, then you could end up in litigation with really no fault on your own. But here you are in a situation where you come to year 15 and you have someone else in the deal than who you originally did the deal with. And they're trying to leverage their position and get more out of this deal than was ever intended. So it's an important right that we try to include and have had some success in doing so. We've touched on a number of different kind of issues to help avoid problems that come up at year 15 and what can actually happen at year 15 if you don't have provisions in your partnership agreement that try to avoid these issues. But what can we actually do to prepare for year 15? Outside of actually drafting language in your partnership agreement to hopefully address some of these issues, what can you do to get ready and hopefully have a successful year 15 experience?
We always say it's never too early to start planning for year 15. We just went through a number of ways you can start planning at year 0, in negotiating your limited partnership agreement. But, once you're in the deal, it's a continuous process, right? So At year 5, at year 10, pull out those agreements, read through them, familiarize yourself with the applicable provisions. What do you need to be doing as a general partner to ensure that when you get to year 15, you're going to have a successful exit? You might want to review the disposition plan from the original underwriting financial projections. What were you thinking that exit would look like at year 15? And are you on track to hit those? You may want to start talking to your investors about possible exit strategies. I mean, we would suggest that this be kind of an ongoing conversation throughout the life of the project. So when you get to year 15, nobody's surprised at what each party's expectations are. Keep on top of your tax capital accounts. Be working with your accountant throughout the life of the project to make sure that those capital accounts are staying at an appropriate level, so that you're not going to get to year 15 and realize the investor partner has an enormous positive capital account that's going to potentially lead to a dispute. That's some of the things to really be thinking about to help you prepare for year 15 throughout the life of the project. Quin, do you want to touch on what are some best practices for actually dealing with year 15?
Yeah, and just to touch on the capital account thing, we've talked about the capital accounts a lot because this is a really heavily litigated aspect at year 15. And so in an ideal world, your investor's capital account at year 15 is going to be like $1, right? You don't want to go negative, but you want to get really close to zero. And so one of the biggest issues that ends up coming up is that people don't look at their capital accounts until they're at year 14 because, who cares about their capital accounts? And so it's really important to do that and to try and work with your accountant to, in as many ways as possible, get that capital account to an appropriate level before exit. In addition to what Christina was talking about, as attorneys, we like to toot our own horn, but it's not a bad idea to get your attorneys and accountants involved at year 0, obviously, but then also when you get close to year 10. Once you hit year 10, year 12, really start working with them, trying to figure out how to exit, how to plan for the exit, what rights do you have. Here's where you really want to work with a professional. And we say it's better to do it earlier rather than later, because they can, for instance, they can do a portfolio review. If you have a number of different properties, different partnership agreements, they can look at your portfolio, identify red flags, and try to address those early on. There's the potential, if you have a really good investor in your deal right now, and if there's issues, there's the potential that you could amend the partnership agreement to address those issues in a favorable way. You really don't want to throw those partnership agreements into the back drawer and forget about them. Make sure you're staying on top of them and that you really review those and identify any potential issues. As part of that, like I said, don't throw those agreements in the back drawer. We've had a number of clients come forward at year 15 and they have no idea where the partnership agreement is. They don't know where all the amendments are. I've actually filed a case before where it was missing some of the amendments to the partnership agreement because they just forgot they existed, right? That's embarrassing for the partner and for the attorney. And it's risky because in the case that I had, the amendment, thankfully, didn't really address any of the real issues, but it could have, and it could have been bad, and it could have, completely changed what we needed, the approach we needed to take. So make sure you know where those agreements are. This is the partnership agreement, financing documents, regulatory agreements, land use restriction agreements, any projections. As far as litigation goes, one of the most valuable tools that a general partner has is a projection when the deal was done, which shows that upon exit, they were only going to get debt plus taxes, right? Or $1 or whatever it is. Any projections that were done would show what the limited partner was anticipating to get at year 15 exit is very telling and is very persuasive as far as what they should actually get at the end of the day. We highly recommend that any communications with the limited partner should be very formal. When it comes to year 15, we're not really buddies. You want to be very clear on what your expectations are, very clear based on what the partnership agreement says. You don't want to make any concessions. Any type of exercise should be in a formal letter, which makes sure that it completely complies with any of the requirements in the partnership agreement. This is not an instance where you're saying, hey, buddy, let's try and figure this out. We don't really think under the partnership agreement, you may be entitled to $1.5 million, but we think you should exit for only $100,000. This is not the circumstance where you want to do that. This should be a much more formal process where you really involve your attorney to make sure it's done properly and that you make sure that you're properly following the partnership agreement and the requirements in there. The final thing that I would say is that you need to make sure that you're on time. Any type of option set forth in the partnership agreement, if it has a timeline, a deadline that it needs to be exercised, for instance, within 1 year of the 15-year compliance period, if you don't exercise it within that year, you generally will waive it. So be on time. Deadlines matter. And so if you think, oh, I'm working this out with a limited partner, and so I'm not too worried about the deadline, we're going to figure it out. No, if negotiations fall apart and you need to exercise it and you've missed the timeline, you've waived it and you're done. So make sure you're on time. This is a very high level discussion. It's hopefully going to give you things to think about, to try and get your mind going on what year 15 may be, how you can address it at year 0. But it's a very brief overview just based on kind of lessons learned and what we recommend to our clients. But Christina has anything additional to add, we sure appreciate you listening to this.
I would just say if you have any questions, any specific issues that are coming up in your deals, or if we talked about anything today that you'd like some more information about, feel free to reach out to us. Quin and I are both available. You can find us online at www.winthrop.com. And we'd be happy to talk to you. Thanks so much.
Thanks for listening.